Okay, so the one thing I like to tell people is that let's demystify what a trust is, because when you say the word trust, they think this is big, complicated legal thing, and it's only for rich people. I don't know what it is. And I always tell people, in your mind's eye, just think of a shoebox. Think of an empty shoebox. That is a visual representation of what a trust is. That shoebox is what's going to, in the contents of that shoebox is what a trust is. You are going to create this trust. You're going to take your stuff, your house, your bank account, your stock certificates, etc., and you're going to fill up that shoebox. And you're going to be inside the shoebox managing those trust assets. So typically you are the lifetime trustee. So you are the trust maker, you create the box, you put the assets in the box, you hold them in the box as the trustee, and you have a list of beneficiaries. So when you pass away, who gets your stuff? And we have special provisions that we can use based upon different circumstances as to who gets what when you do pass away. So this kind of gives you an idea of the parties. You have trust makers, you have trustees, and you have beneficiaries. And when you start out with an estate plan, you're wearing all those hats. So my wife and I are the trust maker, my wife and I are the trustee, and my wife and I are the lifetime beneficiary. I don't have to ask anyone's permission to go to the ATM machine to withdraw a couple $100. It's my money. Right. I'm the beneficiary, and I'm also the trustee. But when I pass away, however, now things are different. Because I put my stuff in trust and I have a successor trustee, we'll just use my dad. I got my dad as a successor trustee. I identified my kids as the beneficiary, and the assets are inside my shoebox. I've already taken all the necessary action to designate a legal fiduciary, my successor trustee. I've identified my beneficiaries, and I've empowered my successor trustee. I've empowered my successor fiduciary to manage those assets, to invest those assets, and to distribute those assets for the benefit of my beneficiary. And so since I took that upon myself, I designated and empowered these individuals, there's nothing for the state to do. There's no probate, because that's what the probate court would have done if you would have died owning assets in your name. If you died owning assets in your name and not in trust, now the court says, well, who do I give it to? Who's the person that has the power to transfer the assets, manage and transfer the assets? There's a whole probate process involved in that. And we avoid that by creating a trust, by pre-planning all this stuff out. And therefore, when someone passes away, the successor trustee steps up. They manage the trust assets for the health, education, support, and maintenance for the beneficiaries, and then those distributions come. And depending upon the circumstances, they can come as a staged distribution at different ages. There could be long-term holds. There could be outright distributions. There could be different assets going to different people. We could be concerned about some more of the protective provisions for our beneficiaries. Maybe you love your kid, but you don't love your in-law so much, your son-in-law or daughter-in-law, and you're worried about the overbearing pressures of that in-law on your children's ability to manage the money. Maybe your kid's a spendthrift, right? You put $1 in his or her pocket and they burn it away in 24 hours. Maybe your kids have drug or alcohol problems. Maybe your kids have special needs issues. Maybe you're very charitably inclined. Maybe your child is a doctor or other kind of professional that's in a high-risk profession and may get sued, and you want to protect that inheritance from the claims of their third-party creditors. All of that can be accomplished with a very basic estate plan as long as it's set up properly. I call these wealth preservation provisions. As long as we have the appropriate wealth preservation provisions, we can create a very strong asset protection plan right within your trust for the benefit of your beneficiaries, whether it be your spouse, kids from prior marriage, et cetera, et cetera, et cetera. And then, of course, you get all the probate avoidance because our shoebox is full, so there's no need for probate, so the time and expense and inconveniences, that's taken care of. And also, we can give some relatively creative instructions, incentive-based, time-based, that you would have that taken care of.